Bismillahirrahmanirrahim. Assalamualaikum and a very good day to Professor Madya, Dr. Tunku Intan Mainura binti Tunku Makmar. My name is Mohamad Amir bin Junih and I will be explaining on what is a treaty and how it is formatted. So, a treaty is a binding international agreement. According to Article 21A of the Vienna Convention on the Law of Treaties 1969, it is an international agreement concluded between states in written form and governed by international law, whether embedded in a single instrument or in two or more related instruments and whatever its particular designation. The Vienna Convention on the Law of Treaties, or VCLT, does not require treaties to have a specific format. Various types of agreements between states can exist, for example, such as soft law or memorandum of understanding, which is MOU, that are non-binding. Treaties can be established between two states, which is bilateral, or multiple states, which is multilateral, or between states and international organizations themselves. A treaty is considered concluded once all parties involved express their consent to be bound by its terms. When there's a dispute about whether an agreement is binding or not, an objective test is used. This test examines the actual terms of the agreement and the circumstances of its creation to determine if it was meant to be legally binding. For example, in the case of maritime delimitation and territorial questions between Qatar and Bahrain, two ministers signed a document outlining several commitments their governments agreed to, some of which were to be implemented immediately. After signing this document, the foreign minister of Bahrain cannot later claim that he intended to sign only a political statement and not an international agreement. The commitments made in the documents are considered binding regardless of how the minister later describes his intentions. And that's the definition of a treaty. Moving on to the formation of treaties. The process of treaty making begins with negotiation conducted by authorized negotiators from foreign ministries who possesses full powers. These negotiators have the official authorization needed to represent their states in the discussions and drafting of the treaty's terms. When it comes to authority, according to Article 7.1 of the VCLT, a person can represent a state in treaty making if they have full powers or official authorization. However, high-ranking officials like head of state, head of government, foreign minister, and head of diplomatic missions are presumed to have this authority automatically and do not need to show their full powers. Under Article 7.2 of the VCLT, these officials can adopt and authenticate treaty texts and express their state's consent to be bound by the treaties without needing to produce full powers. Meanwhile, under Article 8, any act relating to the making of a treaty by a person not authorized to do so will be without legal effect unless the state confirms the act afterwards. Moving on, authentication is the next step, which is typically evidenced by the signing of the document. The treaty itself usually outlines the specific procedures for authentication. If these procedures are not followed, the signature or the initialing by the representatives can serve as sufficient proof of authentication, according to Article 10 of the VCLT. This step confirms that the text of the treaty is final and agreed upon by the parties. The final step is expressing consent to be bound by the treaty, grounded in the principle of free consent, meaning a state cannot be bound by a treaty without their consent. As per Article 11 of the VCLT, a state can show its consent through various methods, including signature, ratification, acceptance, approval, or accession. For instance, Article 12 specifies that a signature can indicate consent if the treaty says so or if it was agreed upon during negotiation. Ratification, detailed in Article 14, involves further domestic approval and an international procedure to bring the treaty into force. Accession, described in Article 15, allows states that did not sign the treaty initially to join it later, provided that the treaty allows this or the parties agree. This structured process ensures that treaties are binding only when states clearly and voluntarily express their agreement, and these are the formation of a treaty.
Assalamualaikum. Let's now delve into the effects of a treaty. Now, according to Article 18 of VCLT, it obliges states not to take actions that will undermine the purpose or effectiveness of a treaty before it officially comes into force. It aims to ensure that the intentions behind the negotiating and signing the treaty are respected from the moment of its signature. So, what is entry into force? It refers to the moment when a treaty, agreement, or law becomes legally binding and applicable to the parties involved. It marks the point at which the terms and obligations outlined in the document take effect and must be adhered to by the parties to the treaty. Entry into force typically occurs after certain conditions specified in the treaty, such as ratification by a certain number of states or a specific date, are met. Once a treaty enters into force, the parties are bound by its provisions and must comply with their obligations as outlined in the treaty. If there is no such agreement, the treaty will enter into force as soon as consent to be bound by the treaty has been established for all the negotiating parties as presumed under Article 24, Clause 2 of BCLT. Hence, it is important to understand the treaties first. There are three interpretations of treaties. The first is the subjective interpretation, where the treaty is understood based on the intentions of the parties involved at the time of its creation. It aims to discern the shared intention and expectations of the treaty's creators and is often utilized when the treaty's language is ambiguous or unclear. Next, the objective interpretation of a treaty. It focuses on understanding its meaning based solely on the text of the treaty itself without considering the subjective intentions of the parties involved. It prioritizes the literal interpretation of the treaty's language and applies general principles of treaty interpretation outlined in international law. Lastly, the teleological interpretation of a treaty involves understanding its purpose or objective and interpreting its provisions in a manner that best serves the purpose. It considers the broader context and goals behind the treaty's creation, aiming to achieve its intended effects rather than relying solely on the literal meaning of the text. Moving on, we will now look into the exception of treaties with consent. To explain this, we will first look into the reservation of treaties. Reservations in the context of treaties refers to statements made by a state when signing, ratifying, accepting, approving, or acceding to a treaty. These statements specify that the state does not accept or will not be bound by certain provisions of the treaty, either because they conflict with the state's existing laws or because the state wishes to modify its obligations under the treaty. Reservations allow states to participate in treaties while still maintaining control over how those treaties will affect their domestic legal systems or international obligations. However, reservations must not be incompatible with the object and purpose of the treaty as stated in Article 19 of VCLT. Additionally, other parties to the treaty have the option to accept, object, or declare that they will consider the treaty as not being enforced between themselves and the reserving state regarding the specific provisions subject to the reservation. So how is reservation to treaties seen as an exception to treaties with consent? This is due to the fact that they allow a state to participate in a treaty while not fully accepting all of its provisions. In essence, while the state consents to be bound by the treaty as a whole, it does so with certain qualifications or exceptions. For example, if State A and State B both sign a treaty, and State A makes a reservation to a specific provision of the treaty, it means that State A agrees to be bound by the treaty except for that particular provision. This can be viewed as an exception to the requirement for mutual consent among all parties to the treaty, as State A is essentially saying, I consent to this treaty, but not to this specific part of it. However, it's important to note that the permissibility of reservation is subject to certain conditions, such as not being incompatible with the object and purpose of the treaty, and the acceptance of reservations by other parties may vary. So, while reservations provide a mechanism for states to participate in treaties with some degree of flexibility, they do not entirely undermine the principle of consent. That is all from me. Thank you.
Hello, I'm Charleson, and now I will be explaining on the application of treaties through various articles of the Vienna Convention on the Law of Treaties 1969. So, Article 26 emphasizes that every treaty in force is binding upon the parties to it and must be performed in good faith. This embodies the principle of pacta sunt servanda and the principle of good faith. Now, what is pacta sunt servanda, you may ask? It means treaties are binding and must be honored. For instance, if a state fails to perform its obligation under a treaty, it breaches both the pacta sunt servanda and the good faith principles. However, this principle may only apply to treaties that are in force, not to those that are invalid, suspended, or terminated. The principle of good faith requires compliance with binding obligations imposed by international law, covering all stages of a treaty from pre-ratification to termination. Now, moving on to Article 27, it states that a party cannot use its internal law as justification for failing to perform a treaty. A notable case is the case of Gabčíkovo Nagymaros project, where Hungary claimed that a mature wrongful conduct ended a treaty on constructing a hydroelectric dam. The court, however, ruled that the treaty was still in force, emphasizing that the parties must find solution within the treaty's cooperative framework. Article 28 of VCLT deals with the non-retroactivity of treaties, stating that a treaty will not bind a party for any act or situation that ceased to exist before the treaty's entry into force, unless the treaty explicitly states otherwise. This can be seen in De Backer against Belgium, where De Backer a journalist was barred from journalism during World War II before the European Convention on Human Rights (ECHR) came into force in 1953. D. Baker argued that restrictions on his civil rights violated his rights under the ECHR, and the court found this restriction justified under Article 10 subsection 2 of the Convention rather than retroactively applying the ECHR. Moving on, Article 30, known as the Clause Paramount, addresses conflicts between successive treaties. If there's a conflict between obligations under the UN Charter and any other treaty, the obligations under the UN Charter prevail. In Lockerbie case, the ICJ prioritized UN Charter obligations over the Montreal Convention. Conversely, in the Genocide Convention case, the ICJ held that jus cogens norms, which are superior to both customary international law and treaty, prevail under any circumstances. Moving on is the death of a treaty, which can be seen as the invalidity of a treaties. There are 5 main types of invalidity, mainly error, fraud, corruption, coercion, and conflict with jus cogens norms. For error, Article 48 of the VCLT states that a treaty can be invalidated if a state's consent was based on an error relating to a fact assumed at the time of conclusion, forming an essential basis of its consent. This can be referred to the case of Temple of Priya Vihar, where the plea of error was not accepted because the party advancing it contributed to the error through its own conduct. For fraud, we can refer to Article 49 of VCLT, which provides that a treaty is invalid if a state was induced to conclude it by fraudulent conduct from another negotiating state. For corruption, which we can refer to Article 50, states that a treaty is invalid if a state's consent was obtained through the corruption of its representative by another state. The corruption must substantially influence the decision, not be a mere courtesy. For coercion, we can refer to Article 52 of the VCLT, which declares a treaty void if its conclusion was procured by the threat or use of force which violating international law principles. For conflict with jus cogens norms, Article 53 invalidates a treaty if it conflicts with preemptory norm of general international law, such as the prohibition of genocide or the use of force. Jus cogens norms are accepted by the international community as norms from which no derogation is permitted. That is all from me. Thank you.